Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, from today's video onwards, we are going to discuss the preliminary exam paper or paper 4 CBI, Central Bureau of Investigation, PPAPP, Public Prosecutor and Assistant Public Prosecutor exams. And in today's video, we are going to discuss the CBI APP PP exam of 2021. So you can see the paper comes like this. As you know that there is combined test for APP or PP or other public prosecutors in other departments such as serious fraud department or in company prosecutor. So there is always a combined test for that. And kindly note this thing, this paper comes in English. And I am discussing in this paper in English. But जहाँ भी possible होगा, I will also make you understand in Hindi as well. But try कि आप जो है English की practice करें. And the last exam paper held in 2021. This is serial number here. This is series A. You have to write your roll number here. The 120 questions carry equal marks and there is penalty for wrong answer. 1/3 penalty. I hope कि ये videos आपके लिए बड़ी useful रहेंगी. So friends, if you are preparing for judicial services, this channel will be very useful for you. आपके लिए बड़ा ही beneficial रहेगा. एंड अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. एंड डोंट फॉरगेट टू सब्सक्राइब दी चैनल एंड व्हाइल सब्सक्राइबिंग डोंट फॉरगेट टू प्रेस दी बेल आइकॉन सो दैट यू कैन गेट नोटिफिकेशन ऑफ आवर अपकमिंग वीडियोस. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए आप जितना भी अमाउंट चाहें डोनेट कर सकते हैं. Minimum is 40 rupees and don't forget to give us a super thanks. So let's move to the questions. Question number 1 is, in respect of which one of the following has the Supreme Court of India recently overruled its earlier decision? देखिए अभी इन्होंने एक वर्ड यूज कर दिया recently. Right to die was earlier held as a fundamental right in P. Rathinam versus Union of India, है ना. Later on, in case of Gyan Kaur versus State of Punjab, it was overruled. However, this is an old case, not recent. So it was freedom to have same-sex relationship. It started with Naz Foundation versus NCT Delhi case, where Delhi High Court decriminalized the Section 377. Later on, Suresh Kumar Kaushal versus Naz Foundation case come up and it criminalized this 377 again. Later on, case Navtej Singh Johar versus Union of India 2018 judgment came, which gave the freedom to have same-sex relationship and consensual sexual relationship. So the answer is C. Next is 2. Which one of the following is the latest addition by the Supreme Court to the rights under the Article 21 of the Constitution of India? These all are also fundamental rights under Article 21. However, the right to internet service. Recently in 2020, Anuradha Bhasin versus Union of India case came up where the right to internet service upheld as fundamental right under freedom of speech and expression. So D is the answer. Next is 3. Which one of the following is provided by the Constitution 104th Amendment 2019? Reservation of seats in favor of SC/STs in all legislative bodies only या फिर House of People as well. Including no. In the House of People and Legislative Assemblies for 80 years from the commencement of the Constitution. It was again revised. So C is the answer. Next is 4. The Constitution of India expressly contains which one of the following kinds of reservation? Maximum of 10% for economically weaker section of citizens. Yeah, it is correct. A is the answer. Then maximum 15% of scheduled caste, no. 7.5% for scheduled tribe, no. 27% for OBC, no. A is the answer. It is mentioned that the reservation for scheduled caste, scheduled tribe and OBC, but the exact percentage has not been mentioned. Article 15 and 16 mentions about the providing reservation to SC, ST and OBC classes. However, there is no maximum cap for a particular caste or tribe. It is mentioned that up to maximum 50%. However, for economically weaker section, the 10% maximum of 10% is particularly mentioned in Article 16(6) of the Constitution. Next is 5. Which one of the following statement about National Commission for Backward Classes is correct? amenable to jurisdiction of High Court? No. It is a constitutional body not amenable to. It is a constitutional body and amenable to the jurisdiction of High Courts. Then it is established by the 102nd Amendment Act 2018 and is amenable to jurisdiction of High Court. This is correct. It is an executive body amenable to all High Courts. C is the answer. And it is mentioned in Article 338B of Constitution, which was added by the 102nd Amendment Act. Section 6. In calculating fraction for terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years. A is the answer. Where it is mentioned? It is mentioned in section 57 of IPC. Section 7. What is the maximum duration for which an offender may be kept in solitary confinement? Up to 3 months only. C is the answer. It is mentioned in section 73 of IPC. And how long he can be in solitary confinement? Once a time. It is mentioned in section 74. Next is 8. R was working with an axe exercising due care and caution. Suddenly, the head of the axe flew and killed a man standing nearby. Which one of the following is correct about legal position in this case? R would be guilty of culpable homicide. No, because he was exercising due care and caution. When there is due care and caution, there can be no offense. Guilty of culpable amounting to murder, या फिर guilty of causing, not guilty of any offense. D is the answer. And this is an accident as per section 80, and this is illustration in section 80 of IPC. Next is 9. Except in cases of sexual offences, the consent of a child would be a valid consent in the eyes of law when the child is above 12 years of age. C is the answer. Where is it mentioned? Section 90 of IPC talks about the consent. Next is 10. K is in a house which is on fire with a 3-month-old baby. People below hold out a blanket. K dropped the baby from the housetop, knowing it well that the fall may kill the baby. His intention was not to kill, but in good faith for the benefit of the baby. Unfortunately, the baby dies by the fall. Which one of the following is the correct legal position in this case? K would be guilty of no offense. Couple said no, causing rashness. No, not. D is the answer. And this is illustration D in section 92 IPC. Next is 11. Normally, a warrant of arrest issued by a court under CRPC remains in force until it is cancelled. Court of superior or cancelled by the court which issued it. Court which issued it. इसमें लिखा होता है until it is executed or it's cancelled by the court which issued it. B is the answer. And it is mentioned in section 70 subsection 2 of CRPC. Next is 12. The code of CRPC is a part of which of the following list under the Constitution of India? It is in concurrent list. C is the answer. It's a repeated question and very common question. Next 13. Under the provision of CRPC, police report क्या होती है? Report filed under section 154(1) no. Forwarded by the police officer to magistrate under 173(2). B is the answer. And the definition of police report is mentioned in section 2R of CRPC. This is 14. Section 2WA of CRPC defines victim as a person who has suffered any loss, injury caused by reason of any act or omission for which the accused person has been charged, and the expression victim includes relatives, guardians, legal heirs. It is guardian or legal heirs of the victim. C is the answer. Definition is mentioned here. Essay 15. Legal aid to the accused at state expense in certain cases is available under which one of the following section of CRPC? Under section 304. A is the answer. Next 16. A is tried for murder of B. Which one of the following is not a relevant fact? A had murdered X and B was aware of that. B was a drug addict. No. B had tried to extort money from A. This is relevant. B had threatened A that he would disclose the information known. Yes, this is also relevant. So, which is not relevant? B is not relevant. B is the answer. Next is 17. Any fact which constitutes a motive is conclusive proof. No. Strong ground for presumption. No. Relevant fact. C is the answer. And it falls under section 8 of Evidence Act. Next is 18. Which one of the following statement with regard to the confession is correct? Confession made to police officer are relevant only in cases of heinous offences. No, not admissible if they are made to police officer while in custody of such officer irrespective of the presence of. No, this is also wrong. Confession are not admissible if they are made to police officer unless it is made in the immediate presence of magistrate. It is correct. This is mentioned in section 26 of Evidence Act. Statement made in police custody are to be discarded totally. No. C is the answer. Next is 19. Which one of the following is not a public document? Record of the acts of tribunal. This is a public document. Record of the acts of police officer of a foreign country. This is also a public document. Certified copy of a will. It is a private document. Public record of private document. This is also a public document. So C is the answer. And which section talks about public document? Section 74. And private document, section 75 of Evidence Act. Next is 20. The burden of proof in a suit or proceeding lies on whom among the following? The defense, prosecution, one who allege, या फिर one who would fail if no evidence at all were given on either side. D is the answer. And this is section 102, burden of proof in Evidence Act. Next 21. Birth during marriage is conclusive proof of legitimacy provided the child is born during the continuance of the valid marriage or within a specified period after its dissolution, the mother remaining unmarried. What is that specific period? 240, 70, 80. 80 days. C is the answer. This is section 112 of Evidence Act. Next 22. Which of the following are the powers and functions of the Central Vigilance Commission? Exercise superintendence over the function of Delhi Special Police Establishment in matter relating to investigation of the offence committed under Prevention of Corruption Act. It is correct. Give direction to DSPE regarding the manner of investigation. No. Review the progress of investigation conducted by DSPE. It is correct. So 1 and 3 are correct. B is the answer. And the powers and functions of Central Vigilance Commission is mentioned in section 8 of Central Vigilance Commission Act. Next 23. No act or proceeding of the Central Vigilance Commission shall be invalid merely because of any vacancy or defect in constitution of the commission, या फिर defect in appointment of the Central Vigilance Commissioner, या फिर irregularity in commission's procedure not affecting the merits of the case. So all of the above हो गया 1, 2, 3 इसमें. 1, 2, 3. B is the answer. And this is section 9 of Central Vigilance Commission Act. Next is 24. The Central Vigilance Commission has the power to inquire into any complaint regarding corruption by a member of All India Services in connection with the affairs of the Union. It is correct. Officer of Group A and B, सारे ही आ गए ना इसमें. Wrong. All employees of government companies, no. Answer is 1 only. A is the answer. And is mentioned in section 8 of Central Vigilance Commission Act. Next 25. Which of the following falls within the domain of Central Vigilance Commission? Advising central government in making rules governing the disciplinary matters relating to persons appointed to the public services is correct. Taking disciplinary action against Group A officer of the central government if found guilty of indulging in corruption. These are mentioned in section 8. Then after receiving report of inquiry found against an officer found guilty corruption, advise the central government about the further course of action. This is also correct. It is mentioned in section 17 of Central Vigilance Act. Next is 26. Which of the following statements about Director of Enforcement and Directorate of Enforcement of Ministry of Finance are correct? He is appointed on the recommendation of committee which includes all vigilance commissioners and Central Vigilance Commissioner. This is correct. He is transferred from recommendation of the appointing committee. Yes. Then he has to be consulted in making all appointments in Directorate of Enforcement. No, this is wrong. Appointment of Director of Directorate of Enforcement is mentioned in section 25 of Central Vigilance Act. So 1 and 2 are correct. B is the answer. Next is 27. The powers of Central Vigilance Commission are that of a civil court while conducting any inquiry under section 8(1)(c)(d) of Central Vigilance Commission Act, या फिर asking any agency to forward any report made by it on reference from commission. See, these all options were wrong. How? 81B and C is mentioned in section 11 of Central Vigilance Commission Act, and it is mentioning here D. So D is not mentioned there. So all options are wrong. You can see that 1, 2, and 3. Exercise 28. Which of the following provisions are applicable to Central Vigilance Commission? Chapter 26 of CRPC. Yes, it is applicable. With regard to the offence affecting the administration of justice. Yeah. Judicial proceeding under 193. Yes. And 228. Yes. These all are mentioned in section 12 of Central Vigilance Commission Act. So answer is 1, 2, 3. C is the answer. Next, 29. The power of Central Vigilance Commission to call for information does not extend to call for report from central government, that the production of return and statement from all departments of central government, ये कर सकते हैं. Call for any information to exercise general supervision over anti-corruption work in central government, ये कर सकते हैं. Call for any information to adjudicate over anti-corruption matters. This is not mentioned. Power to call information is mentioned in section 18 of Central Vigilance Commission Act. So D is the answer. Next is 30. Which of the following are included in the term public servant under Prevention of Corruption Act? A judge and arbiter appointed by the court, assistant professor of university, all of the above. 1, 2, 3. D is the answer. Next, 31. A special judge appointed to try offence under Prevention of Corruption Act can try in summary way an offence committed by a public servant in relation to contravention of any special order under section 12A1 of Essential Commodities Act. Yes, it is mentioned. Then refer to the 12.2A. This is also mentioned. Then 12.2B. No, it is not mentioned. So 1 and 2 are correct. 1 and 2 only. C is the answer. This is mentioned in section 6 of Prevention of Corruption Act. Next, 32. Which one of the following statement regarding qualification for appointing special judge under the Prevention of Corruption Act is correct? तो कौन हो सकता है? A session judge or additional session judge. So C is the answer. It is mentioned in section 4 of Prevention of Corruption Act. Next, 33. When can it be said that the public servant has committed misconduct? When he fraudulently misappropriates for his own use any property entrusted to him. It is correct. When he dishonestly misappropriates for his own use any property entrusted to him. Then when he intentionally enriches himself illicitly during the period of his office. When he is in possession of pecuniary resources or property disappropriated to his known source of income. Yeah, this is also there. It includes in this. So all are correct. It is mentioned in section 13 of PC Act. So 1, 2, 3, 4. D is the answer. Next, 34. Whom the following is authorized to investigate under the Prevention of Corruption Act 1988? So in DSP सब इंस्पेक्टर, या फिर in Ahmedabad an inspector, या फिर in Patna a DSP, या in Calcutta a sub inspector. In Patna a DSP can. C is the answer. This is the provision under section 17 of PC Act where it is mentioned that in case of DSPE an inspector can investigate, and in other states only DSP can investigate. So C is the answer. Next, 35. Identical punishment has not been prescribed under the Prevention of Corruption Act in respect of habitual commission of an offence of abatement of offence of a public servant obtaining valuable thing without consideration from person concerned in business transacted by a public servant. For this, you refer section 11, 12. This includes in there taking gratification to influence public servant by corrupt or illegal means. ये नहीं है. A public servant is honestly misappropriating any property instead of me. This is also included because it is specifically mentioned in section 15 that attempt to commit an offence under section 13(1)(a), and this is 13(1)(a). This is also included. Taking gratification for exercise of personal influence, ये वाला नहीं है. So A and C both are correct. So there are so many mistakes in this paper. Next, 36. Which one of the following statement regarding the Prevention of Corruption Act is not correct? High Court has the power of appeal against the decision of the special judge under the PC Act. This is correct. High Court has the power of revision. Yeah, this is also correct. High Court has the power of review Appeal and revision is mentioned, review is not mentioned. Prejudice has a purpose of appeal deemed the court of session. This is correct. So C is the answer, and this is section 27 of PC Act. Next, 37. Which one of the following is the punishment for an offence of abatement under Prevention of Corruption Act, whether or not the offence has been committed? Not less than 6 months, or 2 years, or 3 years. Not less than 3 years. C is the answer. This is mentioned in section 12 of PC Act. Next, 38. A special judge appointed to try offence under Prevention of Corruption Act may take cognizance of an offence under the Act without the accused being committed to him for trial. Yeah, this is correct. This is mentioned in section 5 of PC Act. Shall follow the procedure of CRPC for trial by warrant case. This is also there in section 5. Shall be deemed to magistrate for the procedure prescribed under section 326 475. Yes, this is also mentioned in section 5. So all are correct. 1, 2, 3. D is the answer. Next, 39. The trial proceeding for an offence under PC Act have to be continued on day-to-day basis until all witnesses in the attendance have been examined, but the trial court can adjourn the case on the ground of that the accused has filed an application before the High Court questioning an order of trial under section 397 CRPC. No, this is wrong. How? The proviso in section 22 of PC Act mentions that provided that proceeding shall not be adjourned, postponed merely on the ground of application under section 397 has been made by the party, and specific court has not been mentioned, so it is also applicable on High Court. Then the counsel of the accused is busy in another court. No ground for adjournment. That the witness is present in the court but counsel does not want to cross-examine. No. Solely to enable the accused to show case against the sentence proposed to be imposed upon him by the court. Yes. So all options are wrong in this question. The provision about this expeditious trial, it is mentioned in section 4 of PC Act. Section 40. In which one of the following cases section 66A of IT Act was struck down by the division bench? This was Shreya Singh vs Union of India. Very common question. B is the answer. Next is 41. While adjudicating on the quantum of compensation under IT Act, which of the following factors are irrelevant? Care and prevention taken in preventing damage to data. No, this is not there. The factors is mentioned in section 47 of IT Act. Amount of gain and fair advantage is there. Loss of amount to any person. Yes. Repetitive nature or default. Yes. So A is the answer. As 42, the central government shall, by notification in the official gazette, designate any organization of the government as nodal agency responsible for all measures including research, development, related protection of critical information infrastructure. Such agency shall be called as National Nodal Agency. A is the answer. And this is section 70A of IT Act, which was inserted by the amendment of 2009. Next, 43. The publication of an electronic signature certificate is prohibited except in which one of the following cases? Where the certifying authority listed in the certificate has not issued it, it is prohibited. Subscriber listed in the certificate has not accepted it. Yes. It has been suspended. Yes. And the publication is for wearing electronic signature created prior to suspension. It is not prohibited. D is the answer. And this is section 73 of IT Act. Next, 44. Every decision under Information Technology Act can be challenged before a civil court or high court by filing writ, या फिर high court by filing an appeal. See, I would say this question is not proper. It is mentioned every decision. So first there is a cyber tribunal. Okay. So that decision can be challenged in appellate tribunal under section 57. Then if they want to challenge the decision of appellate tribunal, then as per section 62 they can go to high court. So I would say this question is not proper. Next is 45. Compounding of which of the following contravention is impermissible under IT Act? So for compounding of offences is mentioned in section 77A of IT Act, and you must also refer the section 63 for compounding of contraventions. So this is mentioned in section 63, and in 77 it is mentioned that any offence more than punishments 3 years and above cannot be compounded. And sending this information is mentioned in section 66A, for which the punishment is 3 years. And fraudulent use of and fraudulent use of electronic signature is mentioned in section 74, for which punishment is 2 years. So only 2 can be compounded, but the options are not correct here. There are so many mistakes in this paper. Next is 46. An adjudicating officer under IT Act, jurisdiction to adjudicate matter involving a claim for damage not exceeding 5 crore. It is correct. Being treated as a civil court. This is also correct. To keep in mind the bona fides of the offender. No, it is not. Power to adjudicate is mentioned in section 46 of IT Act, and this is mentioned there in 46(1)(a), and this is mentioned subsection 5 of 46. So it is not there. So 1 and 2 is the answer. B is the answer. Next is 47. Legal recognition of electronic record would mean only electronically printed record, या फिर record made available in electronic form. Yes. Record accessible so as to usable for subsequent reference. Yes. So 2 and 3, D is the answer. And this is mentioned in section 4 of IT Act. Legal recognition of electronic signature is mentioned in section 5. Next 48. Whom the following shall be the chairperson of the committee constituted for recommending the name of the director under Delhi Special Police Establishment Act? Prime Minister of India. B is the answer. It is mentioned in section 4A of DSPE Act. Next 49. In respect of which of the following the superintendents of Delhi Special Police Establishment vest in central government? In respect of all matters, in respect of matters excluding investigation of offences under PC Act and appointment of officer, exercise the power of superintendents vested in it. 2 and 3. B is the answer. Point 3, section 5 and this section 6A of DSPE Act. Next is 50. The Delhi Special Police Establishment will have jurisdiction in respect of state only with the consent of concerned state, या फिर NCT with the consent of Delhi government, या फिर in the state of Rajasthan regarding railway area in that state. In respect of state only, and consent of Delhi government is not required, and also in the railway areas of any state. So 1 and 3 is correct. D is the answer. Next 51. Delhi's Special Police Establishment is constituted by the central government. A is the answer. Mentioned section 2 of this act. Next 52. The director of prosecution for Delhi Special Police Establishment is appointed on the recommendation of CVC. Yes, it is correct. It is mentioned in section 4BA of Delhi Police Establishment Act, DSPE, and has minimum tenure of 2 years. Yes, it is correct. Shall be an officer not below rank of Joint Secretary of Government of India. It is also correct. So all are correct. D is the answer. Next 53. Which of the following are included in the term person as defined in Prevention of Money Laundering Act? Definition of person is mentioned in section 2(1)(s) of Prevention of Money Laundering Act. As an individual, company, HUF, all are there. So 1, 2, 3, D is the answer. Next 54. Section 5 of Prevention of Money Laundering Act. The director or any other person not below rank of deputy director authorized by him may order the provisional attachment of property involved in money laundering for a period of not exceeding 180 days. B is the answer. And this is mentioned in section 5 itself in subsection 1 itself. Next 55. Whom among the following has the power to arrest a person under section 19 of Prevention of Money Laundering Act? The director, deputy director and an assistant director or any other officer authorized in this behalf by central government. C is the answer. Next 56. Which of the following is the correct composition of an adjudicating authority constituted under the Prevention of Money Laundering Act? A chairperson and 2 other members. B is the answer. It is mentioned in section 6 of Prevention of Money Laundering Act, and definition of adjudicating authority is section 2(1)(a). Next 57. Under section 42 of PMLA, some people also call it PAMLA, any person aggrieved by decision of the appellate tribunal may file an appeal to the High Court within 30 days, 45 days, or 60 days? It is 60 days from the date of communication of decision. C is the answer. Next is 58. In which of the following cases the two conditions for release of an accused on bail under Section 45(1) of Prevention Money Laundering Act were held unconstitutional by the Supreme Court? It was Nikesh Tarachand Shah versus Union of India. A is the answer. Next 59. Which of the following are three stages of money laundering? Placement, layering, and integration. A is the answer. Next is 60. As per Section 4 of Prevention of Money Laundering Act, whoever commits the offence of money laundering where the proceeds of crime involved in money laundering relates to any offence specified under paragraph 2 of Part A of the schedule shall be punishable with rigorous imprisonment for a term which shall not be less than 3 years but may extend to 10 years and shall also be liable for fine. B is the answer. Next 61. Supreme Court can decide matter of policies of the government related to propriety or needs of legislation, whether or not the farm legislation passed by the Parliament in 2020, whether or not farm legislation passed by the Parliament in 2020 deals with trade or commerce or food stuff. D is the answer. Next is 62. Supreme Court was unanimous in upholding the constitutional validity of Aadhaar Act 2016. A is the answer. There was one dissenting, here one dissenting, one dissenting. Next 63. A writ can be issued against central government for violation of terms and conditions of service of a teacher. Yes, can be. Private university. Yes, because they are performing a public function. Private trust running a college affiliated to university. Yes. So 1, 2 and 3. So D is the answer. Next is 64. The state of Telangana prescribes that for admission to all postgraduate courses in various medical colleges in the state, the applicant must be resident of state of Telangana. The rule is, it is invalid because it violates Article 14 of the Constitution. Right to equality नहीं है ना फिर. B is the answer. Next 65. If a state fails to give effect to any direction given by union government to enforce the Essential Commodities Amendment Act passed by Parliament, the effect would be nothing, as state has full executive power. Now, the state would be justified in ignoring the directions as it lacks resources. The president may hold that a situation has arisen in which government of the state cannot carry on in accordance with the provision of the constitution. या फिर union government can move the court for enforcing the directions. The state can take a defense of B. Otherwise, the C can be also be the option. So B can be the answer. Next 66. A state can be challenged to a union territory by following which procedure? Amending the Constitution of India in the prescribed manner, by passing a bill, by introducing a bill on the recommendation of president, या फिर introducing a bill on the recommendation of president after seeking opinion of the state legislature concerned and passing the bill by simple majority in parliament. D is the answer. Next is 67. Which one of the following is not correct? The reservation in employment to public service can never exceed 50%. This is correct. There can be discrimination based on religion with other factors. No. One person can form a class. Yes, it is correct. The concept of criminal layer has been kept in mind under Constitution 103rd Amendment 2019. So which is not correct? B is the answer. Next 68. The right against self-incrimination entitles a person to refuse giving of sample of handwriting, blood sample, thumb impression. ये तो दे सकते हैं. Narco analysis test. D is the answer. And case कौन सा? Which is case Selvi versus State of Karnataka. Next 69. Undue delay cannot be ground to quash criminal proceeding. Yes, it is correct. Modify that sentence to life. This is not correct. Release an arrested person on bail. No, if statutory period is over, then he can apply for bail. And disciplinary proceedings, no. So A is the answer. Next 70. Under which one of the following circumstances does the right to private defense of body extend to causing death? An assault with the intent of wrongfully sustaining a person, या फिर an assault with the intention of committing theft? No. An assault with intention of gratifying unnatural lust, it is there. An assault with an intention of outraging modesty of a woman, no. So C is the answer, and this is mentioned in section 100 of IPC. Exercise 71. Kuldeep, with a guilty intention, abates a lunatic to stab his caretaker. He also supplies a knife to the lunatic in the furtherance of his intention. The lunatic does not do what Kuldeep had asked him and misplaces the knife. Here, Kuldeep would be guilty of abetting the commission of murder. B is the answer. Next, 72. Writing armed with deadly weapon is punishable with imprisonment of either description for a term which may extend to 3 years. Mentioned in section 148 IPC. D is the answer. Next, 73. When two or more persons by fighting in a public place disturb the public peace, they are liable for affray. C is the answer. Section कौन सा है? 159 IPC. Next, 74. Whoever being a public servant fails to record any information relating to section 154 shall be liable to be punished under which of the provision of IPC 166A. B is the answer. Next, 75. Neeraj's brother is contesting elections. One of his friend and neighbor Kapil gets caught up to somewhere on the day of election and does not come to vote. Neeraj tells the polling officer that his name is Kapil and casts vote in the favor of his brother. Neeraj is guilty of personation at elections. C is the answer. Mentioned in section 171D of IPC. Election related offences are mentioned from 171A to 171I. Next, 76. Omission to assist public servant when bound by law to give assistance is a punishable offence under which of the following section of IPC? Section 187. B is the answer. Next, 77. Kailash makes a false entry in his shop book for the purpose of using it as a corroborative evidence in a court of justice. Kailash is guilty of fabricating false evidence. D is the answer. And this is illustration B in section 192 IPC. Next, 78. Karan hits Nitin on his head with a stick several times. Nitin falls unconscious and succumbs to his injuries after 5 days of hospitalization. The doctor testifies the injuries taken cumulatively are likely to cause death. Karan would be guilty of murder. Obviously, B is the answer. Next, 79. Kabir, suffering from an extremely painful terminal disease, begs his wife to give him poison so as to put an end to his pain. She reluctantly agrees and gives him poison, leading to his death. Which one of the following is the correct legal position in this case? She is guilty of culpable homicide not amounting to murder, would fall under exception 5 to section 300. B is the answer. This is 80. The judgment in every trial in criminal court of original jurisdiction shall be pronounced in open court by the presiding officer immediately after the termination of trial or at some subsequent time, of which notice shall be given to the parties or their pleaders. With respect to judgment, which one of the following is not correct? If the accused in custody shall be brought up to hear judgment pronounced, it is correct. If the accused is not in custody, he shall be required by the court to attend to hear the judgment pronounced. Okay, no judgment delivered by criminal court shall be deemed to be invalid by reason only absence of any party. It is correct. For valid delivery of judgment, presence of both parties is essential. No, it is wrong. So they are asking not correct. D is the answer. And this is section 353 of CRPC. This is 81. If upon investigation it appears to the officer in charge of police station that there is not sufficient ground or evidence to justify the forwarding of accused to magistrate, then such officer shall release such accused unconditionally or release him over executing a bond with or without sureties. B is the answer. This is section 169 of CRPC. This is 82. When a person is accused of more than one offences of the same kind committed in 1 year, even though the targeted victims are different, he may be charged with and tried at one trial for how many offences? 3 offences. C is the answer. This is section 219 of CRPC. Next 83. Under section 125 CRPC, a person having sufficient means may be ordered to pay maintenance to his legitimate children only, if minor children only, children married or unmarried, no, or legitimate children not being married daughter who is unable to maintain itself owing to some physical or mental abnormality. Children is correct, but it is mentioned only. So that's why these are not correct. D is the answer. Next 84. When any unlawful assembly cannot be otherwise dispersed, it is necessary to disperse it for public security. Which of the following officer may cause it to be dispersed by the armed forces? The executive magistrate of the highest rank who is present. B is the answer. Mentioned in section 130 of CRPC. Next 85. Section 145 CRPC provides procedure to be followed where disputes concerning land or water may cause breach of peace. The land or water for the purpose section includes which of the following? Buildings, market, fisheries, crops or other produce of land, rents and profit. It is mentioned in section 145. So D is the answer. Next 86. Medical examination of victim of rape is valid only when it is done with the consent of such woman or of a person competent to give such consent on her behalf. A is the answer. And medical examination of victim of rape is mentioned in section 164A. Next 87. Under section 227 of CRPC, where upon consideration of the record of the case, the document submitted therewith, and after hearing the submission of both sides, the judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused. B is the answer. This is 88. Victim compensation scheme is introduced by the Act 5 of the year 2009 by the amendment in which one of the following section in. And now see, this question is not proper. How? They're asking amendment in which one of the following section. Amendment is in section 357. Now they are particularly, they should ask which section is that. 357A. C is the answer. Next 89. In case where the accused pleads guilty, the magistrate may refuse to record the plea, if shall discharge, shall record the plea and necessarily convict him thereon, या फिर may discretion convict him thereon. D is the answer. This is section 229 in summons case trial. This is 113B of Indian Evidence Act, inserted in the year 1986, deals with which one of the following? With presumption as to dowry death. B is the answer. Presumption as to abatement of suicide by a married woman is in 113A, and this was inserted in year 1983. This is 91. Which one of the following is the relevance of testimony given by an accomplice in criminal proceedings? He can be a competent witness against an accused person. Yes, it is correct. His testimony can be accepted only if corroborated in material particulars. This is mentioned in section 114. However, that is only a presumption. It is not mentioned in section 133, accomplice in Evidence Act. His testimony can be accepted only if corroborated by the independent witness. No. Accomplice is unworthy of credit. No. This is also a presumption as per section 114. So he can be a competent witness against an accused person. A is the answer. This is 92. Leading question may be asked during which one of the following? In cross-examination. B is the answer. Section is 143, Evidence Act. Next 93. Which one of the following statement in relation to evidentiary value of hostile witness is correct? It has to be discarded as a whole. No. Declaration of a witness as hostile automatically leads to rejection of evidence. No. It can be relied upon to the extent that being admissible in law supports the case of prosecution and or defense. Totally admissible. No. C is the answer. Provision for hostile witness is mentioned in section 154, Evidence Act. Next 94. A intentionally and falsely leads B to believe that certain lands belong to A, thereby induces B to buy and pay for it. The land afterward become property of A. A cannot be allowed to set aside the sale on the ground that at the time of sale he had no title. This is by the virtue of doctrine of estoppel. A is the answer. Provision in section 115 of Evidence Act. Next 95. Fact forming part of same transaction mentioned in section 6 of Evidence Act. B is the answer. Very common question. Next 96. Certain questions may be permitted to be asked by judge by court or judge in order to discover or to obtain proper proof of relevant facts. This is dealt under which one of the following provisions of the Indian Evidence Act? Section 165. D is the answer. Very common question. Next, 97. Where the question of consent is an issue, evidence of character of the victim is shall not be relevant. B is the answer. Refer section 53A of Evidence Act. Next, 98. Opinion on relationship is a relevant fact in which one of the following cases? Prosecution for bigamy, adultery, if it under Divorce Act, if it determines marital status of two people staying together since a long period of time. D is the answer. It is mentioned in section 50 of Evidence Act, and it has been specifically mentioned there in proviso that it is not applicable on Indian Divorce Act and other sections such as bigamy, adultery in IPC. Next, 99. A child below 7 years of age enjoys absolute immunity from prosecution for criminal case. This is a irrebuttable presumption of fact or law. It is irrebuttable presumption of law. D is the answer. This is 100. Under the provision of Article 110(3) of Constitution, court has no power to decide the validity of legislation of 9th schedule. Yes, court has the power. Validity of legislation enacted to give effect to directive principle under Article 42-46 have the power. The validity of decision of a Speaker of the House of People in deciding whether a bill is a money bill or not. Court has no power. Determining a tax imposed on interstate trade. Yes. So C is the answer. Next one, 101. The Constitution of India provides for impeachment only of President of India. A is the answer. And where is the provision? The power is in Article 56 and procedure in Article 61 of Constitution. Next is 102. Whenever the Constitution of India confers power on the President of India to be exercised at his pleasure, the same has to be exercised on the aid and advice of Union Council of Ministers, except the power to grant pardon, no. Dismiss public servant, no. Give sanction to bill passed by the state legislature, no. Decide the question of disqualification of member of parliament, yes. So D is the answer. Next is 103. If there is inconsistency between laws made by parliament and state, a state law would be valid or invalid? Valid only if it falls under concurrent list and receive the assent of the president. This is 7th schedule of Constitution, but the consent of assent of the president is not mentioned. If a valid law, valid if in pith and substance state law was covered under the entry 2nd of the 7th schedule of the Constitution, and invalid if it is covered in the list 1 of 7th schedule. Yes, it is correct. So D is the answer. Next is 104. The writ of certiorari cannot be issued to call for record of a case pending in district court. कर सकते हैं. Quash decision of tribunal on the ground of violation. Yes. To decide whether a lower court has jurisdiction to decide a case or not. Yes. To direct a person to vacate public office held by him. No. This is quo warranto. यहाँ quo warranto issue होती है तो D इसका आंसर रहेगा. Certiorari can be issued against judicial and quasi-judicial authorities. Next is 105. An all India service can be created in accordance with the procedure prescribed in Article 312 of Constitution या फिर by President by making rule under 309. A is the answer. Next is 106. Article 330 of Constitution does not contain provision relating to reservation in favor of members of Anglo-Indian community. D is the answer. All three are there. Next, 107. The freedom of speech and expression under the Constitution of India disallows disclosure of information pertaining to antecedent criminal background of a candidate contesting election to Lok Sabha. No. Education qualification of a candidate contesting legislative assembly of a state. No. All cabinet papers, yes, they are privileged documents. Violation of human right by Narcotic Control Bureau, no. So C is the answer. Next is 108. The High Court and Supreme Court stand on equal footing in respect of eligibility of a person, appointment as judge, retirement of a judge, removal of a judge, or hearing appeals. Procedure for removal of a judge. C is the answer. Next 109. The fundamental right to equality is not violated if there is a reasonable classification between the person, things, and places having nexus with the object sought to be achieved. Yes, it is correct. Then person is treated as a class. Yes. Special court for trial of special offences is established. Yes. So all three are correct. 1, 2, 3. D is the answer. Next 110. Which one of the following regarding dowry death provided under section 304B of IPC is not correct? Death, natural or unnatural, is necessary. No, it is not correct. Death to take place within 7 years. Yes. Preceded by cruelty, harassment by husband or his relatives. Yes. Cruelty, harassment should be necessarily within connection of demand of dowry. Yes. So A is the answer. Next 111. The Supreme Court judgment in P. Rathina vs. Union of India, it is 1994, not 44, was set aside by the Supreme Court in the case of Gyan vs. State of Punjab, as I mentioned earlier as well. B is the answer. अरुणा रामचंद्र शानबाग ये किस पे है? पैसिव इथनेशिया पर. Next 112. A holds Z down and fluently takes Z's money and jewel from Z's clothes without Z's consent. A is guilty of robbery. C is the answer. Robbery is mentioned where? In 390, theft in 378, extortion in 383, DMP in 403. Next 113. Making preparation to commit dacoity is punishable with rigorous imprisonment up to 10 years. D is the answer. Section is 399 IPC. Next 114. Which one of the following powers have been conferred on Supreme Court? To decide dispute between one state and another. Yes. To transfer to itself any criminal case pending before any court. No. Take disciplinary action against civil servant. No. A is the answer. This is the original jurisdiction of Supreme Court, mentioned in Article 131. Next 115. Which one of the following statement with regard to the duration of the House of Parliament is not correct? 5 years in case of House of People, and Council of State is never dissolved. Yes. 5 years in case of House of People, which can never be extended. No, it is wrong. Every member of Council of State retires. No. Yes. C is the answer. Next 116. Which one of the following statement is not correct? Union of India has power to issue direction to state government to protect the railway within the state. It is correct. Union of India cannot make law for establishment of courts for administration of law made by Parliament in Union. It has power. तो ये हो गया wrong. Parliament can make law on any subject which is not included in the list of 7th schedule. ये correct है. Parliament has power to make law in state list during proclamation of emergency. Yes. So B is not correct. B is the answer. Next 117. Parliament has no power to make law for the whole of India. Wrong. Implementing international treaties. Yeah, ये भी wrong हो गया. Powers हैं GST पर, ये on agriculture ये नहीं है. D is the answer. Next 118. In which one of the following situation can the President of India promulgate an ordinance when the House of People is in session? No, both houses not in session. When both houses of Parliament are not in session and the President is satisfied that circumstances exist rendering it necessary to take immediate action. C is the answer. Ordinance making power of President is in Article 123 of Constitution. Next 119. In which one of the following cases mandated death penalty for murder by life convict under section 303 was struck down by Supreme Court in Mithu versus State of Punjab? C is the answer. Very common question. बच्चन सिंह में क्या था? Rarest of rare case doctrine. Next is 120. Which one of the following is a correct statement? Right to property is a constitutional right. It is correct. Earlier it was in 19(1)(f) in fundamental rights, but it was deleted by 44th Amendment and added as Article 300A as a constitutional right. Judges of Supreme Court never retire. Wrong. Judge of High Court retire and attaining age of 62 years. This is also wrong. Law Commission of India is created under the Constitution now. So A is the answer. So friends, here we have discussed all the questions of CBI PP APP paper of 2021. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो उसको जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. फ्रॉम मिनिमम स्टार्ट्स विद 40 रुपीज़. थैंक्स वेरी मच फॉर वॉचिंग दिस वीडियो. थैंक यू.